It is my honor to introduce our next speaker, Professor Nora Demleitner. Professor Demleitner serves as a faculty member at Washington and Lee School of Law. A graduate of Yale Law School, she has written in many areas, particularly in the area of criminal law, and has a special expertise in sentencing and collateral sentencing consequences. Today, Professor Demleitner will take this expertise to discuss how felons are kept from the ballot box. Please join me in welcoming Professor Demleitner.
Do we have a clicker for the PowerPoint? Oh. Well, good afternoon, everybody. I, of course, also want to thank the law review for inviting me to be part of this truly exciting day here at the law school. So, increasingly, we've seen informal restrictions on the ballot box. Those may take the forms of closure of voting places in a number of states, misleading information about voting times and voting places, and even being thrown off the ballot box, as we heard. Now, there is, however, also a connection between the criminal justice system and voting. So, for example, some studies have documented that the indirect impact of the criminal justice system on voter participation comes to play, for example, with respect to neighborhoods in which excessive policing, especially the infamous stop and frisk practices, occur. Those clearly depress voting participation. Now, my focus today, however, is on a perfectly legally sanctioned form of disenfranchisement, one that closely connects voting rights and the criminal justice system, and that is felon disenfranchisement. What felon disenfranchisement does, it allows for citizens to be legally barred from voting because of a felony record. Now, the impact of these bars is substantial, as we have about 16 million Americans who have a felony record. Some of those individuals are currently under control of the criminal justice system, but many of them are not. They've long completed their sentences, and it is the states that now decide whether and for how long they will be denied voting rights. Now, these bars continue, I will tell you this afternoon, even though we have neither political philosophy nor criminal justice policy that can justify them. Now, lack of a satisfying explanation may be less distressing were the excluded group smaller and less racially skewed. Now, in its broadest form, felon disenfranchisement excludes even individuals who have long been rehabilitated. Yet, they are still treated only as partial citizens. So, automatic long-term restrictions on the franchise are unnecessarily exclusionary. Now, more importantly, what they also do is they hinder reentry and rehabilitation. So it is returning citizens who can vote, returning from imprisonment, who can vote, who have lower levels of recidivism than those who cannot. So what that means is that reenfranchisement really signals to individuals citizenship. It advances and confirms their full participatory rights. And ultimately what that means is that they have lived up to that expectation rather than defeated. Now let's now take a look at these practices and their detailed impact. Now in its broadest form, felon disenfranchisement impacts a large group of individuals, namely those currently imprisoned, pretrial detainees, and those under supervised release. And in a select number of states, those who've long been released from criminal justice supervision. So let me start with those imprisoned. There are, in fact, 2 American states that do not bar anyone from the ballot box based on their criminal record. Prison inmates in Maine and Vermont are permitted to vote. But those are the only 2 states. All other states, at a minimum, disenfranchise everyone who serves currently time in prison or in jail under a felony sentence. That means about 1.5 million people in the United States. In addition to that, there are about 550,000 people who are in jails around the country. Technically, those are not precluded from voting. They have not lost their voting rights. The law considers them innocent. The problem is that administrative hurdles generally and effectively disenfranchise them. They also often do not understand that they retain the right to vote. They may not have the ability to get ballot materials, and often they are concerned that this voting may be held against them at trial or in other later situations. So in the 2016 presidential election, in fact, in Cook County Jail in Chicago, 17% of the pretrial detainees voted. Most of the jails around the country, though, have voting participation of less than 1%. Now, even though the current era is frequently been dubbed the era of mass imprisonment, this term is entirely misleading because our prison system, even though it is exceptionally large, the population that's under supervision actually dwarfs it substantially. So we have 4.5 million people who are on probation or on parole or other form of post-prison supervision. It is state law alone that determines which of these groups is being disenfranchised at any one point. Some states allow probationers to vote, others do not. Some allow those on parole to vote, others do not. Some require that all conditions of a sentence, which also includes fines and any other types of costs that's being assessed, be fulfilled before voting rights are being restored. In fact, it is these financial sanctions that increasingly serve as a barrier. The reason for that is that we, in addition to restitution and court fines, now also increasingly assess what I would call general criminal justice costs. So we're charging in some states people with payment for their incarceration, as if they stayed in a hotel. We charge them with the cost of prosecution, and in a few places we even charge them now with the cost of a public defender, which was not the purpose of that. But that means they carry that debt, and unless they have fully paid it off, they're not eligible to vote. Because of the difference between the states, what we're really seeing is a patchwork model of state disenfranchisement provisions. Now, let's look a little bit more at the interaction between the criminal justice system on the one hand and our voting provisions on the other hand. So you'll see here dramatically how the number of disenfranchised has really creeped up starting in the mid-1970s. You see the dramatic jump in the 1990s, in part due to the war on drugs, but also a whole host of other criminal justice policies. Now, in 1972, the U.S. Supreme Court in Richardson versus Ramirez declared felon disenfranchisement to be perfectly constitutional under the 14th Amendment, Section 2, which allows for this. Now, when the prisons started to fill, of course, the percentage of individuals who were disenfranchised went up. So compared to 1976, we now have 4 times as many people who are disenfranchised. And that's the case even though the states have actually loosened their disenfranchisement provisions in the last few years. Now, the impact on disenfranchisement varies dramatically around the country. So when you look here, in 1980, there were a select number of states, including Florida and Virginia, that had already between 2 and 5% of their population disenfranchised. But look at what has happened. 2016, you now have a number of states. Now, Florida has just changed. This is the 2016 state, but you have a number of states, and including Tennessee, that now have disenfranchisement rates over 5% of their population. So this map has gotten much darker red all around the country. Now, disenfranchisement, however, does not impact every population group the same. Just like our criminal justice system is dramatically, disparately, racially skewed. So if you're looking at the disparate racial impact, by 1980, you already see a dramatic difference between especially African Americans and whites. So this also impacts to some extent Native Americans in certain states. But stunningly, by 2016, you have a fair number of states. And for those of you who cannot read this, the darkest color, that means over 20% of the voting age population, largely African Americans, are barred from voting. And that includes also the state of Tennessee. It is solely a function of who you choose to disenfranchise based on a felony conviction and for how long. Now, there have been a number of attacks, legal, court-based attacks on felon disenfranchisement. They've tried every kind of constitutional theory and the Voting Rights Act. They've largely failed, with one single exception. In 1986, the Supreme Court struck down a part of Alabama's felon disenfranchisement law because of its clearly historical racial bias in the inception of that statute. In fact, the legislatures at the time clearly indicated that these voting provisions, which were also semi-discretionary, were designed to assure white supremacy in the state of Alabama. Now, Alabama subsequently narrowed its disenfranchisement provisions, but obviously still has a substantial one. Disparate impact has not been sufficient, even though you see the charts, it's quite striking for courts to find any kind of legal problem with these provisions. Now, in light of this impact and the magnitude, we have to ask about justifications. So on the one hand, there is political theory, democratic values that may provide a justification. There's really not much. You have the argument of valor and good character. Voters should be upstanding and of an unblemished record. Now, that's generally tied to concerns that felons somehow would band together, become single-issue voters, undermining democracy and passing pro-felon, pro-crime laws. The states of Maine and Vermont do not have any more pro-crime legislation than any other state in the country. The second argument is that felons have violated their part of the bargain, and therefore they've lost their right to participate in a crucial aspect of citizenship. Well, that's why we punish people. The argument can't be we continue to do this forever. Now, closely tied to this argument is a fraud-based argument, and you've heard a bit about fraud this morning already. But here is the theory that felons, because they have such bad character, will of course also attempt to commit almost automatically ballot fraud when they vote. And so, to prevent that, you just preclude them from voting entirely from the start. Now, there's very little, you will not be surprised to hear this, empirical evidence for either the claim of voting fraud or this argument of a pro-crime agenda on the part of felons. My suspicion is that because these arguments are so inherently implausible, they haven't found much favor with the public. In fact, opinion polls indicate that generally the public is not supportive of these felon disenfranchisement laws. And we will see this in Florida, where there was an overwhelming vote to almost abolish all of felon disenfranchisement. Now, the interesting part of Steve's presentation to me was that these public opinion polls have been kind of across the board very persuasive, but there has been a counter-argument that in fact we shouldn't re-enfranchise convicted felons because they are uneducated and they couldn't possibly participate in the political process because they don't understand it. And as a sideline whisper was generally, and they would vote Democratic anyways. so you don't want to re-enfranchise them. Now, there is an argument to be made that probably re-enfranchisement would benefit the Democratic Party more than the Republican. Two very well-known sociologists, Christopher Egan and Jeff Meancer, did a study on Florida specifically. The 2000 election in Florida, probably the presidential election, probably would have come out differently, as well as two senatorial elections would have probably ended with the election of the Democratic senator, who was the Democratic candidate who was running, rather than the Republican who was ultimately elected. That may be true in some other states as well, but certainly that cannot serve as an argument not to re-enfranchise felons. Now, since our democratic values-based arguments are a little bit on the shaky side, maybe there's criminal justice arguments in favor of that. So a whole host of problems for that. First of all, we don't treat felon disenfranchisement as a punishment. We don't consider it a penalty. It's actually not criminal sanction at all. It's a civil sanction. We don't impose it in open court. It befalls people automatically. It's announced as one of the many things that happen to you when you have a felony convictions. And in some cases, there is no time limit that is tied to it. So it's not tied to the severity of the crime. It's not tied to the individual culpability of the offender. It's certainly not proportionate, so retribution can't work. Now, I think we all have to laugh about the deterrent argument. That is not what stops people from committing crimes, especially when they don't even know about it. So incapacitation is our sole argument, but there's really no reason to incapacitate an offender from the voting booth. Now, I haven't talked about rehabilitation, and the reason for that is the evidence there actually runs the other way. That rehabilitation is hindered by felon disenfranchisement, and in fact, re-enfranchisement would help recidivism in terms of decreasing it. So, not surprisingly, in light of these developments, and I think especially the racial impact that is so stark and dramatically uncomfortable, states have moved towards loosening their felon disenfranchisement provisions. That has happened in a whole host of different ways and has re-enfranchised different groups of felons. So some have opened the franchise to those on probation. Some have extended it to those on parole. Some have included both of those groups. Some have re-enfranchised most of the people after their criminal justice sanction is over. Now, the way in which these reforms have taken place has been also very different. In some states, the legislature changed the law. In other states, it was really executive practice that changed. Governors were becoming more willing to restore voting rights in many states. In a few states, in Florida was the leader here, there was a constitutional amendment which changed felon disenfranchisement. This just happened in the last election in 2018. In January of this year, people with a felony record, with the exception of those convicted of murder or a felony sexual offense, were automatically restored their voting rights. What that meant is that 1.4 million Floridians overnight regained the right to vote. And that constitutional amendment passed with 65% of the vote. Not surprisingly, there's one Republican senator in Florida who's now put in a request for a constitutional change, that it would require 2/3 majority to, from now on, change the Constitution in Florida. But for right now, felons have the right to vote there, with the exception of those under current criminal justice sanction. Now, despite these changes, we still have felony disenfranchisement play a substantial role in our system. And there are a couple reasons for that. One is that It remains difficult in many states to regain rights. There's often confusion about the requirements, and I was talking to one of our morning speakers about Tennessee in particular, which has a very confusing statute and quite creates difficulty for people to even understand when they're eligible or if they're eligible, and then to move accordingly. Also, a fair number of states still have executive discretion built into their restoration. So it's often the Board of Pardon and Paroles that makes these discretionary decisions, and depending on who is in charge, they may be at a 95% approval rate, or they may be at a 5% approval rate, which is solely a political decision. Lack of knowledge and confusion are major problems in many of the states. Not surprisingly, the more complicated the law, the greater the confusion. The other problem comes in when you have an interstate move. You may be perfectly fine voting in the state of Vermont with your assault conviction. You're deciding to move to Wyoming. You're not voting anymore in any election, not in a Wyoming state election and not in a presidential election. You'll just have to move to a state that allows you to do that. Confusion often comes in because people don't understand the new provisions in the state they've moved to. Often they're confused about the interplay between a federal conviction and the state voting laws. And in some cases, they're not sure whether they have a felony or a misdemeanor conviction, which obviously has an impact on whether they can vote or not. And then finally, increasingly people with a felony record are, even if they think they're eligible to vote, are concerned about voting. Needless to say, when we heard this morning about all the fraud that is out there, among the few people prosecuted for voting fraud were people who had felony records and voted. There was about a dozen of them in North Carolina, and then probably most high profile, the woman in Texas who was on a supervised release from a federal, not voting related conviction, and then got a 5-year prison sentence in Texas state court, and she had her federal supervised status revoked. So she was going back to prison on both of those counts. Needless to say, if I had a felony record, I probably would be reluctant to register too, because who knows what could happen, right? And that is one of those things that are really disconcerting to people in that situation. So, what should come next? I think we cannot afford the impact on democracy that comes from that large a number of people we have intentionally chosen to disenfranchise without substantial justifications. From a criminal justice reform perspective, which is where much of my work is, it's really highly problematic to continue with this practice that we know is going to at least not support, if not thwart, recidivism and the reintegration and reentry of individuals. And then certainly last but not least is the fact that we have this huge disparity documented on racial grounds, and we know that it exists on socioeconomic grounds because we know that the majority of the people with felony records are not the wealthy in this country. So what comes next? I think we need a national debate about the franchise. We know this after today, but also especially about this purpose of felon disenfranchisement, certainly the scope and the length. Now, let me make a point here that I do not necessarily think we have to abolish every felon disenfranchisement provision. I'll give you my best. I think there are two categories. One is direct attacks on democracy and the state. You're convicted of treason. I think it's perfectly fine if a court, in open court, imposes a lifelong voting denial of the franchise. That should be, however, part of the sentence and expressly imposed. If you commit voting fraud, or in North Carolina, if you're the candidate who supports voting fraud and you get criminally convicted of that, there's no reason why that should not carry an exclusion from the franchise. It doesn't have to be lifelong, by the way, and not everything in this in our criminal justice system has to be multiple decades of a sentence. But certainly it would send a message about the importance of the franchise and how we're using it. Watch for Kentucky. The people who made Amendment 4 reality in Florida have now moved to Kentucky, which has one of the most exclusionary provisions in the country, lifelong disenfranchisement, including for misdemeanor convictions. That's the next state, and I think a lot of people are expecting Kentucky to pass legislation in some form or the other. After that, my personal prediction is Virginia, probably because I live there, but also because we right now re-enfranchise people solely on gubernatorial discretion. Governor from a different party may feel very differently about this. Constitution in Virginia still mandates lifelong disenfranchisement. I think on the litigation circuit, what you will probably see come up is this question of what does it mean under state statutes when it says you re-enfranchise someone when their sentence is completed. Probably we will see this to be litigated already in Florida, where some of the Republican legislatures have indicated that they believe it means having paid off all your fees and fines. Others have argued, no, all it means supervision period will have ended. We will see how this ends, but the easiest way for people who are in favor of disenfranchising felons right now to operate is to basically argue for more financial sanctions coming out of the criminal justice system, which would enable them to just disenfranchise people for a longer period of time. Now, I think it's overdue for us to take this on and really look at this from a global perspective. We can't have this ongoing patchwork that ultimately disenfranchises people. It's a stain of our democracy, and it really makes us exceptional in another way in which we should not be exceptional among Western democracies. Thank you. Think about it. Have about a minute to take a question.
I don't want to hog it, but if no one else has a question. Well, there's a question back there.
Yeah.
I'll defer.
So I have half question, half information. So in Tennessee, you mentioned how strict the law is in Tennessee, and it is you have to pay off all your fines and fees, and you have to be burdened on your child support. But there's this other kind of not uncommon practice in Tennessee where you have to go to various agencies, basically collect paperwork that then you can show to the election commission, who will then give you a certificate that then says you can register to vote. So even if you complete all the parts of your sentence and the return on child support, there's all these kind of administrative burdens. How do those kind of burdens kind of impact the ability for people with convictions to participate when by law they're supposed to be allowed?
I haven't seen any good studies on this, but I think anecdotally, we know that these are huge hurdles. Because the harder you make it, the more paperwork you require for people, the more difficult it is. And I think people, if it's a one-step process, people will go through it. If it's a multiple-step process, it becomes much more difficult. Obviously, it's not free, legal assistance is not available unless it's pro bono. You also, I think, mentioned child support, which, yes, we do want people to pay their child support, of course we do. But why do we have now kind of this extra thing that makes you less of a citizen, that denies you the right to vote, if you haven't paid child support? And if we do that, how is that tied to your felony record? I mean, there's like a lot of disconnect in these laws where I think we're just trying to make people better citizens, but that should not be. I think we've given up on that part of the franchise a long time ago. Thank you.